We have Ivan Golde here, our legal analyst, with us to talk about some of the legal angles of stuff in the news. Hi, Ivan.
Good morning, good morning.
All right, so first let's go local with the big story about the BART police officer, the last one who was there on the New Year's Day shooting Oscar Grant, to be reprimanded. This one let go, one on trial, and the other one let go.
Took a while.
Yeah, Officer Prone, I really think BART is doing this just to lessen their liability. If this case goes to trial, a civil trial, BART wants to say, look, we did everything we could. We trained these officers correctly, and when we found out things went bad, obviously Oscar Grant killed, murdered, so to speak, we let him go. We fired these officers. This way, a jury may lessen the financial punch when a verdict comes down in a civil case. They're just trying to distance themselves from these officers. They're not standing behind them like they did in the beginning. Now they're saying no more. These guys are not BART police officers. We want nothing to do with them.
Okay.
Interesting.
All right. Another thing in national news was this case where an Oregon man, despite his wife's plea to leave him alone, she doesn't even want charges pressed, but I guess it's not up to the victim. She was punched in her sleep and in her husband's sleep. They call it like sleepwalking, sleep eating. In this case, it was he punched her.
Yeah, a sleep disorder. And this is not a novel defense. We have seen this before in murder cases where people claim, look, I was sleeping. I don't remember. That takes away the intent. That takes away the consciousness of guilt, premeditation, everything out the window. This case, like all of these cases, will come down to expert testimony. You have an expert in sleep disorder to examine this defendant, to testify in court. It's a factual question, not a legal question. Will a jury buy that?
Okay, so it's not like if you're shoplifting, you can go after the, I was sleeping. I don't even remember being in that store.
Will a jury buy this? I mean, but I think what would happen is the judge, this would be a plea bargain case. The prosecutor would hear the evidence. This guy has no prior convictions. The wife doesn't want him prosecuted.
Well, that's what I was going to say. I mean, even the wife is, he's never touched me before violently. This is, I mean,
everybody. You know, in a dream, you roll over your mat.
She didn't even want to fight, but I guess it's not up to her.
Well,
the DA has to.
And I'm surprised the district attorney really did charge this case. If in fact, they may dismiss it. They may hear the evidence. What I would do is prepare a lot of things for the prosecutor, have the psychiatrist submit papers to the prosecutor, talk to them, get them to dismiss this case.
These guys have kids. This couple has kids.
And make sure this guy gets help. That's what he needs.
Sleep apnea or whatever he's got.
That's right.
Okay, the last thing was SEC, the Securities and Exchange Commission, has staff, lawyers included. They're supposed to be the watchdogs for Wall Street. And we find out, they do an investigation, they're surfing porn sites during work.
At work, most of the time, you're not supposed to go on the internet. You're supposed to work-related tasks. If these lawyers were doing non-work-related tasks on the internet during work hours, they should be disciplined for that. It's simple. The SEC has had problems, though, in a lot of areas, believe me, of enforcement. I don't know what's going on over there, okay? We'll find out here, but that's a lot. Porn sites during work hours for lawyers at the SEC.
And some of them was egregious. I mean, one person was on it for 8 hours. I mean, the full shift.
I would ask.
How can you fit that in?
I would ask you, do you think those lawyers should be fired for that, terminated for that, placed on probation? What do you think?
Well, here's my question is, I guess, just for broader appeal for anybody who has a job, they can go see your employer every site you've been on all day, right? That's the right?
Yeah, you have no privacy. Correct.
Absolutely. And there's a Google history that goes back years and years and years, and you can check as long as that person's been on that computer, there's a Google history. But then again, these workplaces have rules, and you have to abide by the rules.
And now, how about, is email a gray area, or can they check that to your employer?
Again, they can check that, and again, it's something that is disclosed. If you allow them to do that, you can give your privacy rights up, but if you don't want to work there, you don't have to work there. Certain government jobs, they cannot check your email, but generally, in the private sector, that's something that you negotiate with your boss, and if that's something they want to do to check you, that's one of the conditions of that job.
Have you heard, now I understand if you're using your work email, like your Outlook or whatever that's been issued by work, that's one thing. But what if you're using your work computer to do Hotmail or Gmail, and that's your private account?
You know, it's a real gray area. It's a gray area, but then again, you have to keep that separate. Work, and your question is, can your employer check your private email? Generally, no.
Not private.
And that's what the Patriot Act was all about, with Georgia checking you. Generally, no. But in some instances, you consent. You can do it in writing, verbally, for your boss to do that. So it's a case-by-case basis.
All right, thanks a lot, Ivan.
All right.
9:53, we'll be back with more in a couple of minutes.
The ING Beta Breakers. Watch